Imagine you stole something. Not a car, not a credit card, a piece of meat, a chunk of dried animal flesh that someone else had set aside for winter. It's 40,000 BC. There are no courts, no judges, no lawyers billing you $400 an hour to tell you things you already know. There's just the group, maybe 30 people, and every single one of them saw what you did. What happens next? That question sounds simple. It isn't. Because the answer forces you to confront something genuinely uncomfortable about justice, about punishment, about what it means to live in a community of other humans. And once you see it, you can't unsee it. Let's start with the obvious assumption and immediately dismantle it. Most people, when they imagine prehistoric justice, picture something brutal and instant. You steal, you get hit. You hurt someone, someone hurts you back. Eye for an eye, rock for a rock, end of story. Primitive people, primitive solutions. That's the mental image. Neat, simple, slightly satisfying in a primal sort of way. It's also almost entirely wrong. Here's the thing about small groups. And for most of human prehistory, humans lived in bands of roughly 25 to 150 people. Everyone knew everyone. Everyone depended on everyone. The person who stole your meat was also the person who helped carry your injured child back to camp last season. The person who attacked someone in anger was also the only one in the group who knew how to read animal tracks well enough to find food in winter. In a small, interdependent group, losing a person is catastrophic. You can't just throw someone in prison. There is no prison. You can't just exile someone and feel clean about it, because you might need them next week. And you can't just execute everyone who misbehaves because you'd run out of group members embarrassingly fast. So what did they actually do? The answer, pieced together from anthropological studies of modern hunter-gatherer societies, from archaeological evidence, and from the earliest written legal codes, is genuinely fascinating, and in some ways, more sophisticated than what we replaced it with. They talked first, always. This is the part nobody expects. But study after study of contemporary hunter-gatherer groups, the Hadza of Tanzania, the Kungsan of the Kalahari, Aboriginal Australian communities, finds the same pattern. When someone violates a social norm, the first response is not punishment, it's conversation. The group talks about it, loudly, often, and at length. The transgressor is discussed in their presence and behind their back. They are made to understand, through accumulating social pressure, that what they did is known, that it is not acceptable, and that the group is watching. This is not a soft response. Social reputation in a small group, where you cannot leave and cannot hide, is one of the most powerful forces in human experience. The psychological weight of having 30 people who all know what you did and are all quietly adjusting how they treat you, that is not a slap on the wrist. That is genuinely destabilizing. Anthropologists call this reputational punishment, and it works. For most violations, in most groups, it was enough. But what about serious crimes? What about violence? What about repeated stealing? What about the person who just keeps doing it no matter how many conversations happen around the fire? Here's where it gets genuinely interesting. Because the evidence suggests ancient communities had a remarkably structured escalation system, not written down anywhere, not administered by any official, but consistent across cultures that had no contact with each other, which is usually the clearest possible signal that something is deeply human. Step 1 was reputational damage, as described. Step 2 was material restitution. You took something, you replace it, you compensate the person harmed. This principle, so obvious it sounds too simple, is the foundation of virtually every legal system that would eventually be written down. The Code of Hammurabi, the oldest surviving written legal code from ancient Babylon around 1750 BC, is essentially a very long list of what you owe people when you wrong them. It reads less like a moral document and more like an insurance policy, which makes sense because that's what it was, a formalization of something humans had already been doing informally for tens of thousands of years. Step 3 was ostracism, temporary exclusion from group activities. You don't eat with us tonight. You don't sit at the fire. You sleep on the edge. It sounds mild. In a world where the group is literally your survival infrastructure, it is not mild at all. And step 4, reserved for the most severe and persistent violations, was permanent exile, banishment. You leave and you don't come back. Here's the thing about exile that nobody talks about. In the prehistoric world, it was functionally a death sentence. Not immediately, not dramatically, but statistically. A lone human in the Paleolithic wilderness, without a group, without cooperation, without shared knowledge and shared labor, did not survive long. Exile wasn't a merciful alternative to execution. It was execution with extra steps and plausible deniability. The group got to keep their hands clean while nature finished the job. And then there was execution. It existed, unambiguously. We have archaeological evidence of interpersonal violence in prehistoric remains. Skulls with blunt force trauma. Bodies buried in ways that suggest they were killed deliberately rather than dying naturally. And we have accounts from anthropologists studying living hunter-gatherer communities of what they call altruistic punishment. The group collectively deciding that a specific individual is too dangerous to remain and taking coordinated action to remove them permanently. Notably, this was almost always a group decision, not a single powerful individual passing judgment, but the community reaching a consensus that this person was beyond correction, beyond compensation, beyond exile. A collective act, which is philosophically interesting because it means even the harshest prehistoric punishment had a democratic structure built into it, however informal. The murderer problem. One of the most studied cases in anthropological literature on prehistoric justice is homicide. Specifically, what happened when someone killed another member of the group? The answer is not what you'd expect. It wasn't automatically met with execution. It depended enormously on context. Was it impulsive? A fight that went too far? Was it a genuine accident? Was the victim someone who had themselves been causing problems for the group? Was the killer someone valuable? Someone whose skills the group couldn't afford to lose? These calculations were made, not coldly, not without grief, but practically. The group weighed the loss of the victim against the cost of losing the killer. They considered whether compensation to the victim's family could resolve the breach. They considered the killer's history, their relationships, their value to the group's future. This is not moral relativism. This is resource management under conditions of extreme scarcity, applied to the most painful possible situation, and it maps remarkably closely to the concept of mitigating circumstances that modern legal systems still argue about today. Context mattered then. Context matters now. We just have courtrooms and lawyers to do the arguing instead of a circle of people around a fire. What the first written laws tell us. When humans finally started writing things down, the laws they wrote weren't invented from scratch. They were recordings of things people had already been doing. The Code of Hammurabi, the laws of Ur-Nammu, the earliest sections of Mosaic law. All of them, when you strip away the religious framing and the formal language, describe systems of compensation, escalation, community judgment, and proportional response that would have been immediately recognizable to any hunter-gatherer group from 30,000 years earlier. The idea that justice was invented by civilization is backwards. Civilization inherited justice. It just added bureaucracy. Here's the uncomfortable part. For all the sophistication of ancient community justice, it had a fundamental flaw. It only worked inside the group. For people who were members, who had relationships, who had reputations to protect, it was remarkably effective. Recidivism in small, tight-knit communities is genuinely low. Social pressure and reputational stakes keep behavior in line with remarkable consistency. But for outsiders, for strangers, there were no rules at all. Someone from another group had no standing, no reputation, no relationships that constrained how you treated them. The same community that carefully deliberated for days over how to handle a theft between members would feel no similar obligation towards someone they didn't know. This is not an ancient failing we've completely solved. It is a tension that runs directly through every modern debate about who deserves the protection of law and who doesn't. Who counts as inside the group? Where the boundary falls. Ancient humans didn't invent that problem. They just had smaller groups to argue about it in. So what did ancient humans do with criminals? They talked, they pressured, they demanded repayment, they excluded, they exiled. And when all of that failed, they made the hardest decision a small community can make together. What they didn't do, mostly, was act alone. What they didn't do was hand the decision to a single person and call it justice. What they didn't do was build a system so large and so abstract that the humans inside it stopped mattering as individuals. Some of what they built was brutal. Some of it was quietly wise. All of it was trying to solve the same problem we're still trying to solve today. How do you hold a community together when one of its members tears at it? We've been working on that answer for 300,000 years. We haven't finished yet.